There are things police do every day that people swear are illegal, and they're not. And misunderstanding these powers is one of the fastest ways that people talk themselves into charges. And a quick note before we start. Police powers vary a bit state by state and by situation. The principles I'm explaining are general across Australia, but the exact rules depend on where you are in Australia and what the situation is. I say this as somebody who has been a police officer and a prosecutor and now a lawyer. So here are 5 of the most commonly misunderstood police powers. The first is, police can approach you and ask questions without reasonable suspicion. In fact, without any suspicion at all. Police don't need a reason to approach you and ask questions. So long as they're not exercising an actual power, they're free to do whatever you might do on a street, and that could include walking up and talking to somebody. What they usually do need suspicion for is when they're detaining you, which is a specific legal process and is entirely separate to arrest. They also are usually exercising powers when they ask you to stay, or they ask you official questions when they believe that an offence may have occurred or you may have something dodgy on you. When that happens, they have to do a few things like use a proper caution and tell you who they are, what station they work from, and the power that they're exercising. But this is where people get confused. Talking is not the same as detaining or using a power, so there's really nothing to prevent them from talking to you in the first place. And a voluntary conversation can happen without suspicion. But because of the inherent power imbalance, often people feel like they are compelled to speak to police and they are compelled to answer questions. You're not, but it can feel that way. And this is going to sound somewhat insane, but if you start becoming really defensive and cagey about things, that may raise some suspicion, fairly or otherwise. A much easier way to deal with it is just to say, look, I'm sorry, I don't feel like talking, and then if they press the point, ask whether or not you're being detained. A lot of charges start here, so that's the easiest way to prevent something from spiraling out of control. Now, the second thing is that you don't get a lawyer with every interaction. In fact, you don't have a right to a lawyer in every interaction. A lot of people seem to think that the moment police speak to you, you are entitled to a lawyer. It's simply not the case. Your rights to a lawyer depend on what's actually happening at that stage of the interaction. Informal questioning is different from being arrested. Roadside requirements, whether it be for an RBT or an RDT, is different to a formal interview at a police station. But once you're in custody and an interview is on the table, safeguards around legal advice and support people tend to start to come into the mix. And they're usually read to you by a custody manager, who's a sergeant in custody at a police station. But assuming you're not in a formal interview, there's no requirement for police to stop asking you questions simply because you say you want a lawyer. There's also generally no requirement to provide police with an interview in the first place. That's why often you'll hear lawyers saying, don't interview. And I've done videos on that if you want a deeper dive into why that is. But remember, if you don't want to answer questions, say exactly that. People get into trouble where they assume the rules are the same in every situation. Number 3, police can and do ask questions that they already know the answers to. This one really upsets people, and I understand why. It feels unfair. But police are allowed to ask questions they already know the answer to, and no, it is not entrapment. Entrapment is a very specific situation. Knowing the answer to a question that you're asking is just good investigation. And they do it to test your version, to test the consistency of the story, and most importantly, they can do it before they show you the evidence. And this only becomes a legal problem if it crosses a boundary and starts to become, coercion, threats, or an application of improper pressure. And not all pressure is improper. Most of the time when people say, well, the police tricked me, you may well be right, but that doesn't mean that there's a legal recourse for it. The risk is never in the police question. The risk is in the answer that you give. Number 4, police searches do not require proof. One of the biggest misconceptions that I see is people seem to believe that police require proof to be able to search you, and often it's the opposite of that. For many common police searches, it's not true at all. The threshold is reasonable suspicion, not certainty. Police don't have to be right, they have to be reasonable. And not all searches are the same. Some searches require a warrant. Some happen because you've been arrested. Some depend on consent, although I'd caution against consenting to a search. There's really no need to in any circumstance. And some have higher thresholds and stricter procedures. They're things like digital device warrants, where they go through your phone. Whether a search is lawful depends on the specific power that's being used, the threshold for that power, and whether or not procedure is being complied with, not what they find. So police can search you and find something, but if there wasn't a reasonable suspicion in the first place, that search can get thrown out. But remember, arguing at the side of the road never helps. Make a mental note of it and deal with it later if needed. The key takeaway is not every search is an illegal search, and not every find makes a search legal. And wrapping it up, number 5. Arrest does not require the magic words in the first few seconds. Television has caused real confusion about arrests. And it's true, police usually do have to tell you that you're under arrest and why, but it doesn't have to happen immediately. The general obligation is that it must be when reasonably practicable, and that may mean when the situation has calmed down or when it becomes less dangerous. It depends on the circumstance, but it doesn't need to be immediate, and that's the thing that people get confused on. In fact, the absence of the words may not invalidate the arrest at all. In New South Wales, if police don't give you the arrest, they don't give you the caution, it doesn't necessarily mean that the arrest was unlawful. The law changed around this, and I'm not going to go into the sections unless you want it, in which case I'll put it in the comments, but it's just something to keep in mind. What matters with an arrest are the actions, not the script. If a reasonable person in your circumstances may believe that they're under arrest, then often that is enough to be under arrest. There can be an arrest by actions alone. The takeaway is this: fixating on the technicalities is almost never the answer, and often it can make things worse. Now, none of this means that police can do whatever they want. They can't. But misunderstanding what police can actually do puts you at a serious disadvantage. Most of the people that I see who've been charged didn't do anything wrong in the sense of what they did when they were interacting with police. They were just relying on myths that don't apply in Australia. If you want law explained the way it actually works in real life, subscribe. I'm breaking down how the law actually applies to people in this country properly, honestly, and clearly. That's my entire goal here. And if you have recommendations on things that you'd like explained or myths that you've heard or seen, let me know in the comments.